everybody. I'm Stephanie Dahl with Dahl Fisher, your estate planning, business, and probate attorneys here in Denver, Colorado. And today I wanted to talk about something that I have heard from a lot of different people on an idea how to avoid probate. I hear a lot of, the baby boomer generation or even the greatest generation saying, I'll just put my kids on the deed to my home. And then that way, the house doesn't have to go through probate. It'll just automatically transfer to my child upon my death. And this is a really bad idea for a lot of reasons. And the reason I say that is because one, when you own a house and then you put someone, a lot of times people will do it as a quit claim deed, and they will put their daughter or their son or somebody on. When they do that, they have now made that child the owner of the property with them. And the problem with them being the owner of the property is now your home is considered an asset for purposes of that child. So if that child has creditors, if that child is going through a divorce and it is a nasty divorce and they are also titled on this property, that the soon-to-be spouse could come back and say, that's an asset of my ex-spouse and I'm entitled to the appreciation, half of the appreciation. Like I said, creditors. And then one of the other reasons that it's a really terrible idea is because when somebody passes, we get what we call step up in basis, which means that from what you purchased it at to when you pass away, it steps up. And then that becomes the new basis for the person who inherited that piece of property. And then any accumulation in the asset after that will then result if there's taxes and things like that. But they get that step up in basis first before that tax liability is calculated. And so the problem is that when you bring them on, they don't get that step up in basis for their share. And so the problem is that especially here in Colorado with real estate, I have a lot of clients who purchased a home way back when, and they purchased it at $15,000. And now it might be worth $750,000. And to waive that for them to get the step up in basis, it is a huge tax bill that's going to come due that nobody was anticipating. So one of the things we always tell our clients is make sure before you start doing things because you are trying to avoid probate, that you don't actually do something that's going to set you up to end up costing you or your estate or your child more money than if you had just gone through probate, or you had just sat down and set up an estate plan that involved a trust and all of these different things. So just things to think about. Just remember, sometimes what you read on the internet isn't always true. So make sure that you ask a professional who can tell you whether or not this is the right decision for you. But most of the time, we will not ever tell you, yes, put your child on a deed, because it just is not in anybody's best interest, quite frankly. So if you have any questions or you want to talk to us about anything, please feel free to reach out. You can reach us at 303-758-7700 or at dollfisher.com. Thanks so much and take care.